Call on the Minister for Financial Services to say the prayers.
Let us pray. Almighty God, from whom all wisdom and power are derived, we beseech Thee so to direct and prosper the deliberations of the Legislative Assembly now assembled, that all things may be ordered upon the best and surest foundations for the glory of Thy name, and for the safety, honor, and welfare of the people of these islands. Bless our Sovereign Lady, Queen Elizabeth II, Philip, Duke of Edinburgh, Charles, Prince of Wales, and all the royal family. Give grace to all who exercise authority in our Commonwealth, that peace and happiness, truth and justice, religion and piety may be established among us. Especially we pray for the Governor of our islands, the Speaker of the Legislative Assembly, official members and ministers of Cabinet, and members of the Legislative Assembly, that we may be enabled faithfully to perform the responsible duties of our high office. All this we ask for Thy great name's sake. Let us say the Lord's Prayer. Our Father, who art in heaven, hallowed be Thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. Lead us not into temptation, but deliver us from evil. For Thine is the kingdom, the power, and the glory, forever and ever. Amen. The Lord bless us and keep us. The Lord make His face shine upon us and be gracious unto us. The Lord lift up the light of His countenance upon us and give us peace now and always. Amen.
Please be seated. I have apologies for the Honorable Speaker, who is still a bit under the wind. I'm also informed that late arrival of the Deputy Governor, so I give apologies for until his arrival.
Reading by the Honorable Presentation of papers and reports. Segregated Insurance Fund of the Cayman Islands financial statements for the year ended 30th of June 2013 to be laid on the table by the Honorable Minister of Health, Sports, Youth and Culture.
Call on the Honorable Minister for Youth and Culture.
Thank you, Mr. Speaker. Mr. Speaker, I beg to lay on the table of this Honourable House the financial statements of the Segregated Insurance Fund of the Cayman Islands for the year ended 3rd of June 2013.
So ordered. Does the Minister wish to speak thereto?
No, thank you, Mr. Speaker.
National Gallery of the Cayman Islands financial statements for year ended 30th of June 2013 to be laid on the table by the Honorable Minister of Health, Sports, Youth and Culture.
Honorable Minister of Health.
Thank you, Mr. Speaker. Mr. Speaker, I beg to lay on the table of this Honourable House the financial statements of the National Gallery of the Cayman Islands for the period year ended June 30, 2013.
So ordered. Does the Minister wish to speak thereto?
No, thank you, Mr. Speaker.
Statements by honorable members and ministers of the Cabinet.
I have no notice of statements. I now call on the Honorable Premier.
Thank you, Mr. Speaker. Mr. Speaker, I move the suspension of Standing Order 14, Suborder 3, in order that government business may take precedence over private members' business on today, Thursday.
The question is that government motion take precedence over private members' motions. Honorable Member from East End.
Thank you, Mr. Speaker. Just to ask if the government, if it is their intention that we will take up the private member's motions as soon as the government business has been completed today.
Honorable Premier.
Mr. Speaker, I had gotten an indication from the member who just spoke yesterday that he would be content for the private members' motions to be put over until my return from the UK next Friday. If he is still so content, I certainly would prefer dealing with them in that way. The matters which are proposed in all three of the private members' motions are matters that require some careful consideration by the caucus of the government. And quite frankly, we have not had the opportunity to properly consider these matters collectively, as you are aware, Mr. Speaker. And so it would suit us if these matters could be put over until my return from the UK next Friday.
Member from East End.
Thank you, Mr. Speaker. I wonder if the Premier can give us a date that we would be coming back to deal with these matters. Certainly, I speak for me at least, and I think the member from Northside who has the private members' motions listed, we certainly will be cooperative in that regard, so the Premier can get on with the duties he has to do in England. But what time will he be back, and what time will we resume to deal with these? Mr. Speaker, the member from Northside is indicating that Wednesday the 12th, I'll be receptive to that too. I'm not one way or the other.
Honorable Premier.
Mr. Speaker, I understand that the Leader of the Opposition is also going to be away. Indications from my colleagues here are that the 18th would be our preferred. 18th is Tuesday, but the 17th. The 17th would be our. The 19th?
19th.
Fine. Fine, the 19th.
You're back by then? Okay.
The 19th. I think that would accommodate everybody in the House. These are very important motions, and I really would want the Leader of the Opposition to be present.
Member from East End.
Thank you, Mr. Speaker. Mr. Speaker, I find that some of us has to be absent at some stage. There is a deputy leader of the opposition who can convey anything any position the opposition takes. The Premier, we appreciate the Premier. He also has a deputy, but in this instance, the matters that he has to deal with, I don't know, but I'm sure they're in the interest of this country. And certainly we would like to have the Premier here to reject it or accept it. But I mean, you know, the world goes on, and this country has to go on, and we can't wait for everybody. At some stage, some of us are going to be missing, but we have to make provisions for the most important people in this country that the people have sent here to run the country, which is the Premier and the Deputy Premier. But we can't forever be waiting on the leader of the opposition, and we need to get these things on the way, and I can't support that.
The question is that Standing Order 14.3b suspended. Those that are in favor, please say aye.
Aye. Aye.
Those that are against, no.
No.
I think the ayes have it. Accordingly, Standing Order 14.3 has been suspended. Madam Clerk.
Government business, bills, second reading, the Standards in Public Life Bill, 2013.
I now call on the Honorable Premier. Order.
Mr. Speaker,
Honorable Premier.
You can say that again.
Quiet, please. Order. Honorable Premier.
thank you, Mr. Speaker. Mr. Speaker, I beg to move the Standards in Public Life Bill 2013.
The bill has been duly moved. Does the mover wish to speak thereto?
Yes, Mr. Speaker. Thank you. Mr. Speaker, the bill, which is full entitled A Bill for a Law to Preserve and Promote the Integrity of Public Officials and Institutions and for Incidental and Connected Purposes, shortly entitled the Standards in Public Life Bill 2013, is a bill that has been the subject of considerable discussion for a long time. It has been duly published. It complies with the constitutional provision with respect to notice. It's been published since October. Mr. Speaker, its genesis is Section 117 of the Cayman Islands Constitution, Order 2009. And Mr. Speaker, you and other members of this Honorable House will recall that one of the important parts of the new Cayman Islands Constitution Order was the section entitled Institutions Supporting Democracy. And the Commission for Standards in Public Life is one of those institutions which the new constitution establishes. Under that part, Mr. Speaker, are also the Human Rights Commission, the Constitutional Commission, the Advisory District Councils, the Complaint Commissioner, the Register of Interest, and Freedom of Information, all of which form part of the overall package to assist in promoting good governance and supporting democracy and promoting the rule of law in this jurisdiction. Mr. Speaker, the first commission was appointed on the 1st of February 2010, and since then it has met diligently and has reported to this House every 6 months. The commission is about to make its 8th report. Among the work that the commission has completed has been a code of conduct developed in accordance with Section 117, subsection 9, subsection F for public authorities and public officers. And the Commission also adopted what are known as the Nolan Principles as part of its precepts and guiding principles. Mr. Speaker, for the benefit of those who may not be entirely familiar with the Nolan Principles, I will quickly go through them. And it is notable, Mr. Speaker, that the principles are actually appended to the Standards in Public Life Bill as Schedule 2. They include selflessness. Persons in public life shall act solely in terms of the public interest. They shall not do so in order to gain financial or other consideration for themselves, their family, or their friends. Integrity. Persons in public life shall not place themselves under any financial or other obligation to individuals or organizations outside the relevant civil service entity that might seek to influence them in the performance of their official duties. Objectivity. In carrying out public business, including making public appointments, awarding contracts, or recommending individuals for rewards and benefits, persons in public life shall make choices on merit. Accountability. Holders of public office are accountable for their decisions and actions to the public and must submit themselves to whatever scrutiny is appropriate in their office. Openness. Persons in public life shall be as open as possible about all the decisions and actions that they take. They shall, as required by Section 19 of the Constitution, give reasons for their decisions and restrict or withhold information only when the wider public interest clearly demands or where a law allows for the withholding of information. Honesty. Holders of public office have a duty to declare any private interests relating to their public duties and to take steps to resolve any conflicts of interest arising in a way that protects the public interests. Leadership. Persons in public life shall promote and support these principles by leadership and example. Those, Mr. Speaker, are the Nolan Principles, and those form the basis for the Commission, the Standards in Public Life Bill, and indeed guided the development of Section 117 of the Cayman Islands Constitution, which has enshrined those principles in the Constitution itself. Mr. Speaker, up until the present time, all that we have with respect in writing with respect to the Nolan Principles or anything approaching them is the Register of Interest Law. And the Register of Interest Law has very limited application currently. Schedule 1 of the Register of Interest Law only requires the following persons to register their interests: elected members of the Legislative Assembly, the Speaker, the Deputy Governor, the Attorney General, the Financial Secretary, the Registrar of Interests, candidates nominated for election to the Assembly, and somewhat curiously, also journalists who report on activities in the Legislative Assembly, Mr. Speaker. But it doesn't have any wider application than that. And so, Mr. Speaker, the Commission having been established and having been charged with responsibility under the Constitution for, among other things, the Register of Interests, which is set out in Section 121 of the Constitution, charged also with responsibility for monitoring standards by persons in public life, charged with responsibility for ensuring that government contracts are properly tendered and that the process is fair and equitable, charged with the responsibility for ensuring that conflicts of interest, that there are no conflicts of interest, or where there are conflicts of interest, that appropriate measures are taken. The Commission determined that it needed bespoke legislation to be able to carry out its constitutional mandate and responsibility. And so, Mr. Speaker, that has been the genesis of the bill that is now before the House. I should say a bit, before I go into the provisions of the bill, Mr. Speaker, and I should advise members that there are a number of committee stage amendments that are being proposed. I asked for those that have been circulated last night, and I do hope all members have had an opportunity to review them. I do not really propose to speak to the committee stage amendments at this stage in my presentation, but if issues are raised in the debate of other members when I wrap up or wind up debate on this bill, I perhaps will address any concerns then. If not, the usual discussion can take place at the committee stage. But returning, Mr. Speaker, to the Commission for Standards in Public Life itself, as I said, this is established under Section 117 of the Constitution. It consists of a chairman or chairperson and not less than 2 nor more than 4 other members who are appointed by the governor, acting after consultation with the Premier and the Leader of the Opposition. At least 1 member of the Commission shall be a chartered or certified accountant of at least 10 years' experience, and at least 1 member a legal practitioner who has practiced in the Commonwealth for at least 10 years. Members of the Commission for Standards in Public Life shall be people of the highest integrity with knowledge of practice in the private or public sector. The functions of the Commission are to assist in the setting of the highest standards of integrity and competence in public life in order to ensure the prevention of corruption or conflicts of interest, to monitor standards of ethical conduct in the Legislative Assembly, the Cabinet, and on the part of public authorities and public officers, to supervise the operation of registers of interest and to investigate breaches of established standards, to review and establish procedures for awarding public contracts, to review and establish procedures for appointing members to public authorities and the terms of their appointment, to recommend codes of conduct to prevent any minister, public authority, or public officer employing their power for any personal benefit or advantage, and to recommend legislation to provide appropriate sanctions, to report to the Legislative Assembly at regular intervals and at least every 6 months, and to exercise such other functions as may be prescribed by a law enacted by the legislature. Mr. Speaker, the key features of this bill is to provide the Commission with the legislative framework needed to fulfill its constitutional mandate as set out in Section 117, subsection 9, and Section 121, subsection 5 of the Constitution. As I said earlier, it widens the category of persons who were previously subject to completing a declaration under the Register of Interest Law in 1996, which this bill will now repeal. In order to do so, the bill creates a category of what are called persons in public life, which are set out in Schedule 1 to the bill, which include all members of the Legislative Assembly, including the Speaker, chief officers and deputy chief officers in the public service, chief financial officers and deputy chief financial officers, heads of departments, sections or units and their deputies, as well as any other organized entity within a ministry or portfolio, statutory authority, statutory body, government company, department, section or unit, and their deputies, chief executives of statutory authorities, government companies and their deputies, members of governing bodies of statutory authorities, members of governing bodies of government companies, members of all commissions created by or under the Constitution, a person holding a full-time or part-time position in a public authority who engages in an activity that is in conflict, is likely to conflict, or may be perceived to conflict with his position in a public authority, and any other person specified by regulations made by the Cabinet. As I said at the start, Mr. Speaker, the bill adopts the Nolan principles as the principles which persons in public life must adhere to. And I went through them in some detail, but repetition bears emphasis, as one of my forebears in this House used to say. And the principles are selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. The bill, Mr. Speaker, mandates how a person in public life must deal with any possible or perceived conflict of interest which arises during the course of his or her duties in order to avoid instances of corruption or perceived corruption. This includes taking no part in any discussion or deliberation of the matter before them and recusing him or herself from the portion of the meeting that discuss any matter that is likely to be perceived as a conflict. It requires persons in public life within 30 days of the 30th of June this year to make a declaration annually to the Commission, which provides in relation to himself or any connected person details of their income, assets, liabilities, including amongst others any shareholdings, contracts with a public entity and association. The full list, Mr. Speaker, is set out in Section 12, subsection 1 of the bill, or I should say clause 12.1. No board member of a statutory authority, public authority, commission, or government company, that is, members of governing bodies of statutory authorities, members of governing bodies of government companies, and members of commissions created by or under the Constitution, is required to include in a declaration any interest unless there is a possible or perceived conflict with his functions on the entity to which he or she is appointed. When there is doubt as to whether an interest is a conflict, the Commission shall make such a determination. Clarifications of the positions are proposed as committee stage amendments. Mr. Speaker, I should point out here that the obligation with respect to board members of statutory authorities, public authorities, and commissions and government companies, the ones I just ran through, are different and less onerous than those with respect to members of the House and civil servants. Essentially, the difference is that with respect to those who are members of this House, the Speaker, and those who are, and the civil servants who are set out in the schedule, they are required to make full disclosure with respect to all of their assets and the source of their income outside salary. But with respect to board members, they are only required to make such disclosure where there is a conflict, or there could be the perception that there is a conflict with the exercise of their particular duties. For instance, if you are a member of the Central Planning Authority that is considering for approval plans with respect to a particular development, and you are in some way involved with that development because you were the architect who drew the plans or that you are bidding on the job, you need to make that disclosure with respect to your activities, because there is an interest or a perceived, there is a conflict, a potential conflict, or at least the perception of a conflict could exist. Mr. Speaker, the bill provides the Commission with the powers of investigation where it suspects a person in public life has committed a breach of this law. Such investigations may result as a consequence of the Commission's own initiative or from an allegation made by a person. So, Mr. Speaker, if someone complains that they believe that a person in public life has a conflict of interest or is engaged in some corrupt practice, they are able to complain to the Commission, and the Commission now, by virtue of this proposed legislation, will have the power to investigate that complaint. Without this legislation, although the Commission is mandated to monitor standards, it doesn't have any investigative powers. These powers mirror that of the Grand Court, allowing the Commission to summon witnesses, require the production of reports, documents, etc., and take any other such necessary actions as it considers expedient for the purposes of carrying out its functions. Mr. Speaker, the bill contains provisions to protect whistleblowers and information. It is noted that the initial declarations filed by persons in public life will be available to members of the public. It is anticipated that this will occur via the Commission's website. Additional information obtained during the course of an investigation will be privileged. The bill also provides guidance to Cabinet on appointing board members. This is contained in Part 6 of the bill, to ensure that each board has the skills, knowledge, and integrity to carry out the duties required of the position in a highly competent and politically neutral manner. It further allows for the removal of board members in instances where a board member is unsuitable to continue to serve or a conflict of interest has arisen which would bring disrepute to the board. Mr. Speaker, it provides for members of this House to continue to be held to a high degree of standing in that any contravention of this law by a member shall constitute contempt of the Legislative Assembly, and the Assembly may order that member's suspension from sitting and voting in the Assembly for a determined length of time. This is contained in Section 33, subsection 1. The bill, Mr. Speaker, provides for penalties of up to $100 a day when a person in public life submits a declaration outside the 30-day period, Section 11, subsection 5. Further penalties of up to $10,000 and/or imprisonment for a term of 2 years for persons who fail to furnish a declaration or required information, provides false information on his or her declaration, or fails to appear before the Commission when summoned. During the course of an investigation, any person who fails to comply with any of the Commission's requirements is liable for a fine of $50,000 and/or imprisonment for a term of up to 2 years. Mr. Speaker, this is a serious piece of legislation. It is a further demonstration of this administration's commitment to good governance in these islands. This is a commitment which we have made. It is a commitment we take most seriously. And underpins our view, Mr. Speaker, our belief that good governance is at the core of the well-being and continued success of these islands. We must ensure that those who are in public life carry out their functions with absolute integrity, and that everyone, those who live here and work here, those who do business here and invest here, can do so in the belief, satisfied that all the matters that are dealt with, all the decisions that are taken by boards, statutory authorities, members, senior civil servants, and members of this House are taken on the basis of the Nolan principles, and that self-interest and conflicts of interest do not influence or color the decisions that are taken. And so, Mr. Speaker, I am happy to say that we are today ticking another one of those boxes with respect to the undertakings that we have given when we stood for public office, when we published our manifesto, when we said that one of the principal things that we were going to ensure was the restoration of confidence, the repair of the reputation of the Cayman Islands government, that we were going to ensure that integrity and principle were tenets of our administration. And so I am proud, Mr. Speaker, to be able today to introduce such an important bill, which will have far-reaching consequences, but consequences that I believe will be nothing but positive for both the reputation of these islands, but also for the administration of the affairs of government. I thank you, Mr. Speaker.
Does any other member wish to speak? Honorable member from North Side.
Thank you, Mr. Speaker. Mr. Speaker, I rise to support a bill for a law to preserve and promote the integrity of public officials and institutions, and for incidental and connected purposes thereto. And I take the opportunity to congratulate the government for bringing this bill. I do have a few concerns. I agree with most of the bill, but I do have a few concerns, and I understand that in order to raise it in committee, I need to mention it in the debate so that I have full license to question them in detail in the committee. I will start with section 4.1c, a legal practitioner who has practiced in the Commonwealth for at least 10 years. I would be much more comfortable, Mr. Speaker, if that said in practice in the Cayman Islands for that 10 years. I know that the next subsection says that he has to be a Caymanian to be appointed, but we know there are several forms of Caymanians these days under the immigration law. And having been the subject of one of these inquiries where they hired Idi Amin's former Chief Justice to investigate me, I'm worried that somebody could come here from a similar area of the Commonwealth and be appointed to this commission because he got Cayman status through, in a short period of time, through being an investor or one of the other lightning bolt type provisions that gives people Cayman status when they want to come here. So I would be a lot more comfortable if that said that legal practitioner practiced in the Cayman Islands for at least 10 years. Because I believe we have to recognize our own, and I think we have enough Caymanian legal practitioners that we can find these kind of people from, and we don't need to go abroad and appoint somebody who, although he is a Caymanian, if you ask him at the bar where he's from, he's not going to tell you Cayman. He's going to tell you somewhere else, and they always have somewhere else to go. So that's one of the things that I will try to get changed in the committee. I also don't understand why we believe we have to be more generous to people in public office than we are to members of a political party, in that members of a political party or politicians are prohibited from being a member for 5 years, but public servants and civil servants is only 3 years. I think both should be 5, because I think it is necessary to have a separation before you get appointed to such an important commission. But I don't see why public servants only need 3 and we need 5. And I also have some concerns, Mr. Speaker, about 5.3. It says a report, statement, communication, or document which the Commission makes an exercise of its functions, or which a member makes in the performance of his duties, shall not be used in legal proceedings if the governor certifies in writing that such production is not in the public interest. Given recent history, tempura, etc., I have great concerns about giving the governor the authority to unilaterally decide that some document or information that some person may need to use in legal proceedings, in civil cases, or I think this would probably, I got to be careful here, Mr. Speaker, because somebody will tell me that I'm not a lawyer, and it might not refer to criminal cases. But I don't think the governor should have the authority to say that if a Caymanian needs to use information here in a civil case under this caveat undefined, because public interest is not defined in the law. And that could simply be that it mentions somebody in the UK government or the governor himself or herself. I agree with the amendment that has been filed to 8.2. I also have some concerns, Madam Speaker, because we're making legislation for the future, and 12.1L, any other details as cabinet may prescribe in regulations. I think when it's related to this section, that should require an amendment to the law and it should come to the Legislative Assembly. No, you know what you're doing. No. Anyway, in section 15, to Mr. Speaker, I'm a little concerned that the Commission only has to keep the records for 3 years. And I think that 5 years might be more appropriate, because that at least includes a term of the Legislative Assembly. Because here, they could destroy the record before the full term of a legislator, and there would be no record of what you started and what you finished at. So I think at least that should cover the period elected to the Legislative Assembly, so that it's easier to compare what you came into the Legislative Assembly with and what you're leaving with. If the record is destroyed after 3 years, there's no way of knowing what you came in year 1 and what you're leaving in year 4 with. I would be more comfortable with 5 years. I also have some concerns, Madam Speaker, and I know that the Premier, in moving it, talked about the investigative powers, which I agree with, that is giving to this Commission. But I would also be happier if we allow the Commission to prosecute. And I think we have to provide them with the resources, and they can go out and get whatever resources they need. But I think one of the things that holds up and reduces the effectiveness of these kinds of commissions is that after the commission does its work, we then go to the police, we have to refer it to the police, and then who has to refer it to the DPP, and in some instances that could take a long time. And I don't see why we're afraid to give the commission the powers to prosecute on its own findings, because the courts are going to be the ultimate arbitrator. And I think if we look to the Anti-Corruption Commission in Hong Kong, the thing that separates and ensures the success of that Anti-Corruption Commission is because it can prosecute, and is not subject to somebody else deciding that what they have recommended as an offense is not worthy of prosecution. Because I would believe that the caliber of people that we're putting on this commission, if they determine that somebody committed an offense, then they should be able to prosecute it and not rely on some other entity who would not necessarily have been involved in the whole investigative process. And I believe that if we're serious, which I think we are, because the legislation is here, in talking about and implementing the Nolan principles, we have to give these commissions the resources with which to work and achieve the objective that we ask them to do. We shouldn't let them off the hook by allowing them to have the excuse, well, we referred it to the police. Recent history, the ICTA claimed their interpretation of the law was that they were not responsible for content and broadcast. But there's no other authority in the country responsible for any content. And even when a legitimate complaint is put before them, they simply refuse to deal with it by saying that it's the police that needs to investigate, not them, and the police don't respond to the written complaint. And there are other provisions in the law that gives the governor permission to intervene immediately. And you write them on the same complaint, and nothing is done about it. So I believe that we have to give these commissions the resources and ultimate authority. Oh, well, the government let him off the hook. They gave him a reward and sent him home. The point I'm making, Mr. Speaker, is that I believe that we have to give these important commissions the best possible chance of achieving the objective for which they were created. I do not believe that telling them after they have done all of this investigation, they have found something that they believe they can prove is wrong, that findings is then subject to some other arbitrary decision of a facts or whatever that they arrive to their decision on. I think if they are brave enough to do the investigation, they have a findings, give them the authority and the resources to prosecute themselves, and let the court be the arbitrator. And another thing that I don't like, Mr. Speaker, is several times we see that the cabinet may do certain things to bring this law into effect. I think the cabinet, that should be shall and not may. Because there's no success in putting these things on the books, and then all that is necessary to make them effective is not done ASAP. And the part I'm talking about where they have to refer to is in 22, where the Commission is satisfied on the basis of an inquiry conducted under this part that a breach of any of the provisions of this part has been committed, or an offense has been committed, it shall forthwith refer the matter to the Royal Cayman Islands Police Service and the Director of Public Prosecutions, together with a certified copy of the declaration in question and a report of its findings. In any case where the Commission determines that the subject matter of an inquiry under this part is A, already under investigation by the police, whether or not charges have been preferred, or already the subject matter of proceedings in a court of law, the Commission shall hold its own inquiry in abeyance, pending final disposition of the investigation of these proceedings. As I said earlier, I believe that and I'm not sure that in 24, it refers to Section 11, which I believe is the register of interest is a public document. Any person in the public can ask that it be seen. I don't know where then it says that the Commission shall not divulge to any person or authority information or any document disclosing it under Section 11. Because reading the earlier part of the bill, I assume that the register of interest was a public document that could be inspected by any member of the public during normal working hours. And I just want to make sure that this section doesn't conflict with that and contradict it, so that somebody can say, well, Section 24 prohibits me from seeing what somebody else put on it. And as I said, Mr. Speaker, I'm not a lawyer, so I could be wrong. I'm just taking a common sense approach to what I read. Now, Madam Speaker, this under section part 6, notwithstanding the provisions of any other law, I'm really curious about this, and I don't understand the provision. Board members of a public authority shall be appointed by cabinet, and one of those board members shall be appointed to be the chairman by the cabinet. Is that going to refer, because I think that some of the laws that currently exist, cabinet appoints the board members and a separate person is appointed chairman. So there may be some instances where, because the way I read this is that the person that was going to be appointed chairman has to be one of those who's appointed under the other section of the law about board members. As long as there's no conflict in it, I don't have a problem with it. So, Mr. Speaker, with those few short comments, I support the legislation. I congratulate the government on bringing it here. I think it's timely, and I think it's a good piece of legislation, but I do have those concerns about the legislation, and I will seek to have them addressed individually in committee stage. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? I call on the fifth elected member for George now.
Thank you, Mr. Speaker. Mr. Speaker, I campaigned on a return of ethical leadership and good governance to the East Cayman Islands, and I rise to support the Standards in Public Life Bill 2013, or as it's named, the bill for a law to preserve and promote the integrity of public officials and institutions, and for incidental and connected purposes. Our leaders must live by the highest code of ethics in order to restore confidence, trust, and respect in the hearts and minds of the people of the Cayman Islands and also the world. I think the first step in reestablishing good governance was the election of responsible, accountable leaders who are committed to put the interest of the country first. And I think this bill proves that commitment and that it's a good second step in order to restore good governance in the Cayman Islands. That first step, Mr. Speaker, I believe was the reestablishment of the relation, of a good relation with the UK. In fact, Mr. Speaker, in our national priorities plan, my independent colleagues and I promise to pass and implement the Standards in Public Life Bill if elected, and thus we are happy as part of this government to be putting our weight behind it. I can only speak personally, but, and I'm sure my colleagues will echo this, but I am extremely happy that this is one of the priorities of this government. We have to go further, though, Mr. Speaker, in our quest for political reform. When we're looking at our leadership and good governance, we have a few steps to ensure appropriate procurement systems with a center of excellence approach and to strengthen the penalties for public office improprieties. I think, like I said before, this is a good step, but I would charge my colleagues that we have a long way to go, but in these 4 years, we can accomplish that by enacting good legislation such as this bill. Therefore, Mr. Speaker, with those few words, I'm happy to support the passage of this bill and the amendments thereto that were sent out yesterday. And I suggest that because of the importance of this bill, we all promise to improve public awareness of what constitutes conflicts and corruption. Because we have to be seen as transparent. We have to be seen as leading the way. And we have to be seen as just and upright leaders. In improving the awareness in our electorate, letting them know what constitutes good and bad behavior and what is corruption, we will have strengthened them and we will have strengthened this country. Mr. Speaker, I come from a governance background. That's what I did as my career. So I am very aware of the risks of not doing it right. I think we also have to amend our anti-corruption law to address perceptions relating to conflicts of interest, to also ensure that what is seen is also done. It's already in the Constitution, and it's already adhered to by members of Cabinet. We need this to be done by all members of our community in order to stamp out some of these practices. We have also started as this government to proactively look at the third pillar of this, which is financial accountability. and putting in place policies, because we recognize that good financial management is a key to good governance. So, Mr. Speaker, with those few observations, I am quite happy that we are on the right track in putting the country back to where it needs to be by building a strong base of good governance and practices and implementing the Nolan principles and the other areas as set out in the objects and reasons of the bill. And I thank the Premier for bringing the bill to this honorable House, and I'm happy to support it. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? Recognize the second elected member for Georgetown.
Thank you, Mr. Speaker. Yes. Mr. Speaker, I rise today to also publicly state my support for the Standard and Public Life Bill as it is now stands before us for approval in this Assembly. Mr. Speaker, I was one of those original commissioners and was very much involved in the drafting of this legislation. Not drafting it, but in contributing to the legislation as it was being drafted. I resigned my commission on January 20th, 2013, once I declared my candidacy for the legislature. And so I was never able to see this piece of legislation or see it being implemented during my term as a commissioner. And I know that for the first 4 years of the Commission's existence, it has hampered its work. It is because this is so necessary to allow the Commission to fulfill its constitutional mandate. But I have to say I'm delighted today that the Premier has brought this legislation forward, because it would give me opportunity now on the other side of the fence to be able to see this legislation implemented, finally come to fruition, to give the Commission the power and the authority it needs to conduct its work in bringing transparency and a heightened sense of ethics within the public service and for all persons who work in public life. Mr. Speaker, I think it is important for any person dealing with a person in public life, whether it be the civil service or within the legislature, wherever, public authority, statutory authority, government company, that whoever they are dealing with, the person is dealing with them is free of conflicts, whether they are real conflicts or perceived conflicts, because there is a distinction, but the two can create the same issues or problems. And that however and whoever they are dealing with, they're dealt with in a fair and impartial manner. And ladies, Mr. Speaker, sometimes we think conflicts are a bad thing, that they're evil, but they exist everywhere in life. They exist in everyday things that we do. The question is, how do we deal with those conflicts? They need to be mitigated wherever they can be mitigated or eliminated. And I'm glad that there are provisions here to deal with these conflicts when they do arise, because I believe so many times we have seen throughout history and throughout times where conflicts are not disclosed, and sometimes citizens of this country are disenfranchised by the outcomes of decisions taken by people in public life. Underpinning this legislation are the Nolan principles. Mr. Speaker, I too come from a background of high ethics and transparency in my former role as a managing partner of one of the accounting firms here. I've lived all my life under a microscope in terms of how I invested, what I was allowed to invest in, and had that monitored on an annual basis. So I'm accustomed to this type of life. I'm accustomed to identifying conflicts of interest and mitigating them, or avoiding them in the first place. So this is nothing really new to me. But I'm grateful too to see that these types of principles will now be ensconced and become a part of the ethos and the mindset of our public service. But Mr. Chairman, the challenge that we face going forward is that the wider, all persons in public life will now need to be trained on these principles, educated on them, helping them to understand what these principles truly mean in their life and what it will mean for them in terms of their daily decision making, to ensure that the real meaning and the true intent of this legislation is achieved. So I think that our public service will have some challenges, but I think that they have, in terms of educating and bringing these things forward and implementing them within the public service to ensure that the intent is achieved with this legislation. Mr. Speaker, I'm delighted to say I will be supporting this legislation, and I'm looking forward to voting at the appropriate time, because it would give me great pleasure to see this legislation finally come to fruition for the Commission and for the people who have worked so tirelessly over the past 4 years to see it come to this point. And with those few comments, Mr. Speaker, I will conclude my debate and contribution to this legislation. Thank you.
Does any other member wish to speak? Does any other member wish to speak? I recognize the Honorable sixth elected member for Georgetown.
Thank you, Mr. Speaker. Mr. Speaker, I rise quickly to also offer my support to this bill, titled A Bill for a Law to Preserve and Promote the Integrity of Public Officials and Institutions, and for incidental and connected purposes. Mr. Speaker, a few short weeks ago, we were here passing another monumental bill into law, and that was a national conservation law. Mr. Speaker, that law preserved our natural environment for our future, for our children's children, for our children's grandchildren. Today, Mr. Speaker, we are here with the Standards in Public Life bill, another important piece of legislation, but this time preserving the core values of our people and our government. It is a responsibility of us, Mr. Speaker, the leaders of this country, to display the highest level of honesty, integrity, and principles. We are the ones that set the standards. We are the ones that the young people of this country look up to. We are the ones that the students in our high schools read about and study. We are the ones that our students in universities are following. And we are the ones that are making the decisions that will affect the rest of their lives. Mr. Speaker, I have always been an advocate for transparency, and I've also been extremely outspoken, even prior to getting involved in politics, with regards to conflict of interests on boards and in our authorities. So, Mr. Speaker, in many instances, I have seen many upright and good citizens have their reputations tarnished just because of the perceptions of them being in a particular position. We put them there to compromise their integrity. They can go there with the utmost of the right intentions. However, one little incident, one view, one perception of a particular case or of a particular matter can ruin that individual's reputation for the rest of their lives. It doesn't matter all of the good they did in the past. That one incident can ruin all of that and ruin their reputations. And this is why I believe that this bill is so important. So that we can operate these boards, we have to rely on the expertise of volunteers, Mr. Speaker. I know there's a stipends with a few of those, but it really, the persons that we're asking to take those posts, they're not there for the money. They're volunteering their expertise and their time for the betterment of this country. And without procedures and policies and laws in place, like the standards in public life, we are putting those persons' reputation at jeopardy, Mr. Speaker. So I am very happy to rise here today to offer my support to this bill and to say that I will be voting for the bill and its amendments later on this morning. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? I recognize the Honourable fourth elected member for Bordentown.
Thank you, Mr. Speaker. Mr. Speaker, I also plan to be brief, but I'm rising to give my support for this bill. I'm sure many people remember on the campaign trail that I talked about supporting this legislation and supporting any move that this government made to further transparency. And I am sticking to that promise. And as the Premier mentioned earlier, this is another check that we can put on that list of things that we promised to do. I campaign, Mr. Speaker, for transparency. And I believe that if I am prepared to operate under the principles and standards set in this bill, I don't see why anyone should have an issue with doing the same. We are representatives of the people, and we have to represent according to the highest standards and in the most transparent way possible. Mr. Speaker, our government has suffered from a perception that corruption or favors, cronyism exists, and I've seen it and I've heard about it when I deal with some of the boards and board members and people who'd have to deal with the boards. And I applaud the government for pushing this issue because I think we need to stamp that perception out. The more we can do to clean up the perception that any government operates in that way, the more the country will benefit. The Premier has mentioned earlier that he is going to be on an international talk show in the UK in the near future. And I'm sure that he's going to be grilled with numerous questions that may be aimed at our reputation internationally. And I think this bill is a shining example of what we're prepared to do to defend and protect this country from unwarranted accusations and threats. Anything we can do to clean up our reputation, Mr. Speaker, I will support. I want to thank the Premier and all individuals who were involved in bringing this bill forward. I think it was something that has been waiting for quite some time, and I know we have moved it forward since the introduction of the new Constitution. And while it may seem academic for most, it is quite an accomplishment, and they should be applauded for their efforts. I agree with my colleague from Georgetown, Mr. Speaker, that we must do everything we can to help those individuals who we put in positions of power and trust to not become subject to unfair accusations. And the more we can do to make the operations of those individuals transparent, the less opportunity others will have to criticize and condemn. So with those few short words, Mr. Speaker, I offer my support for this bill, and I will be voting in the affirmative. And thank you.
Does any other member wish to speak? I recognize the Honorable Attorney General.
Thank you. Thank you, Mr. Speaker. Just to say a few words in support of the bill. Mr. Speaker, the issue of integrity in public life is very current, very topical throughout the world, and of course, no less so in the Cayman Islands. As a small jurisdiction, we have, over the years, consistently developed practices and legislation to confirm our willingness to take steps to comport with what has been considered international norms of transparency and openness, certainly in respect of the conduct of public life and also matters dealing with people and persons in the private sector. Mr. Speaker, that is why we have signed numerous tax exchange agreements. We have embraced numerous conventions that have been extended to us and have put legislation in place to give legislative effect to them. Start with the Mutual Legal Assistance Treaty, we did the Vienna Conventions, we did all of those matters. In some countries, of course, conduct in public life is regulated by and large by what is called conventions. The Nolan principles that we are espousing today, enshrining in legislation, and some of the other concepts that are embodied in this are values and codes that other countries observe by way of conventions, but they are nonetheless extremely important. We have gone a step further and enshrined them in legislation, giving them legislative underpinning. We have, Mr. Speaker, in 2008, we enacted the anti-corruption law. For that, we have the Public Service Management Law, which has certain provisions in it dealing with codes of conduct for civil servants. We have our customs and conventions that guide parliamentary conduct of parliamentarians and others in public life. But, Mr. Speaker, and we have had our challenges over the years, and we will continue to have challenges. The honorable member from Georgetown mentioned about the need to educate our board members. If you look at most of the statutory authority laws, you will see that it speaks to the issue of conflict of interest. But it is clear from some of the things that we've seen, some of the issues that we have been confronted with, that there are, in a number of cases, genuine misunderstanding as to the import of those provisions. Some people think that all you really need to do is to make a declaration and stay and participate in the meetings. And that is notwithstanding the fact that in some of them it makes it clear that you recuse yourself after making a declaration and have it recorded. So there is a lot to be done. I mean, this is impossible to legislate integrity in public life. It is impossible. It takes more than that. It takes a cultural thing, is a sort of a sea change. Well, I shouldn't say a sea change, but really what it means, it has to do with the person. People understanding the import of these things. So legislation will say one thing, but unless you have the right body, the right mind, the right mindset to give effect to the requirements of the legislation, we'll continue to have challenges. And so, of course, it doesn't help being in a small jurisdiction where you're looking for certain expertise to put on boards and commissions, and you're looking for people with requisite knowledge, background, and so on. And some of these people are involved in businesses where they have to make their own living, have to care for their family, and the government is trying to draw on their expertise, and they have to find a way to balance that with their ability to conduct their business and make a living. So it's a balancing exercise. We want the best minds, the best expertise on these boards, but they are faced with the possibility of, well, if I sit or serve on this board, it simply means that my business is going to be compromised, or my ability to make a living has to be put on hold, and so on. And it's always going to be a challenge to find the right people to put on boards, and so on. But I agree that if you're going to ask for efficiency and good administration, then you need to find persons with the right skill set. Mr. Speaker, over the years, the world, and I say the world, has focused on us because there is this perception that there's this perception, that we are not where we should be in terms of international benchmarks. And I say perception because each time that we have been reviewed, and God knows we have been reviewed fatigue by now. We have been reviewed by just about everybody, everywhere. Any sort of initiatives that they come up with, the Cayman Islands is a guinea pig for these. So whether it is the FATF, the OECD, the GAO, the Committee for Fiscal Affairs, just about everybody. Cayman Islands is a place to start with, and so. And I don't know if they think that there is something that is hidden under some rock somewhere that they have not been able to discover, but they've always come up short. Because the fact is that we have gone much further than some of our colleagues, some of our metropolitan countries.
True.
When you look at how we comply with the recommendations under the FATF, Cayman Islands sits at the top of these countries, major European OECD countries. Cayman sits at the top of the apex in terms of a compliance with the recommendation set by the FATF. So if you look at what happened in terms of information exchange in tax matters, the same thing. The Cayman Islands is very much sitting at the top of the apex with all these other countries and so on. But for some reason, we have not been able to shake some of these things. We have had anti-corruption law in place. We have the UK Bribery Act that applies to us. We have the convention itself that has been extended to us since 2010. We have been told what we knew all along, that as far as the United Nations Convention on Corruption is concerned, we have the necessary legislative framework in place to give effect to it. We have an anti-corruption law long before that. So we are at that stage where we are ready to have the convention extended to us to basically sort of augment, if you will, our existing legislative framework with these things. And so we are very much there. And we have every reason to be proud. We have had our challenges, but name me one country that doesn't have in these things. So we need to continue to demonstrate that we are a country that take these things seriously. We have public officers, we have parliamentarians, we have people in our judiciary, we have all over the place, persons who do understand and embrace these values and attitudes as it relates to our conduct in public life and good administration. The bill is an excellent bill. It deals with, as I said, some of the things that other countries do by way of, are observed by way of conventions and customs. We have codified them in legislation, and this is very important. And so it's also important to note that there is a sort of a comfort for just about every potential stakeholders. And by that I mean those who are genuine whistleblowers and who are aware of things happening, transgressions taking place, and are prepared to come forward and make a report. They are protected under the legislation. Clause 20, I think clause 23 provide necessary protection for these whistleblowers. But the contrary is also true. Clause 17 too makes it quite clear that busybodies will be punished. So those who think that it is good and in order to make unfounded and unnecessary allegations against people and just want to be busybodied, well, clause 17 of the bill says that you run the risk of being prosecuted and being dealt with severely. So it provides comfort to both sides, all stakeholders. And I certainly welcome the passage of this legislation, which is, although the bill says, the title of the bill is a law to preserve and promote integrity in public life, I would certainly say it's a bill to further preserve and promote integrity in public life, which is what it is. These are incremental steps we're taking in this area, and the effort and the passage of this bill is something that this entire House should embrace. Thank you.
Does any other member wish to speak? I recognize the Honorable Deputy Governor.
Thank you, Mr. Speaker. No, I will be brief as well. But first, I want to commend the government for bringing this bill to the House. It is timely and necessary. The Civil Service welcomes the bill, and I would go as far as say as the bill shines a light over the Civil Service, and it promotes transparency within the Civil Service. For quite a while, Mr. Speaker, I think all of us would have heard allegations that civil servants or senior civil servants were making decisions based to further their interest. And this bill makes it very clear that that is not possible, but it goes further. If someone believes that I am making a decision based to further my benefit or in a situation where I have a conflict of interest, because I am required to fill out the register of interest, they can view that on the Commission's website or by visiting the Commission's office. And if they believe that I have not been truthful, they can make a complaint and the Commission can then investigate. And I think that is very important in that we have provided the Commission with the necessary teeth for them to carry out their work, and that for the bill to have the necessary penal provisions so that it would be a deterrent to anyone who would seek to violate the law once passed. Mr. Speaker, I also support the section on whistleblowing, as the Honorable Attorney General said. I won't rehash that, but that has been one of our shortcomings for quite a while, and that we have not been able to provide whistleblowing protection to persons who come forward with information. People say that they are reluctant to come forward with information because they are afraid that they will lose their jobs or some other action will be taken against them. And Clause 23 of the bill makes it very clear that they will now have adequate protection. Mr. Speaker, I believe one of the other benefits of the bill is that it promotes investor confidence in our islands. I think investors coming here want to be assured that the elected government and the civil service arm of government are all observing the Nolan principles, which is set out in Clause 2 of the bill. And I believe that will go a long way to assure investors that the Cayman Islands is open for business, and we are happy to regulate ourselves and promote transparency and accountability. Mr. Speaker, a lot of work has gone into this bill, and it would be remiss of me if I did not thank the Commission for Standards in Public Life, all the commissioners, past and present, in particular the chairman, Mrs. Thompson, for all their hard work, and the Commission Secretariat, Ms. Borden, who is here, and other members who have worked very hard on this bill. I know that our civil servants in legal drafting have done a tremendous amount of work in putting this together, dealing with some committee stage amendments, and I want to recognize all of them for their hard work. Again, in summary, Mr. Speaker, I want to thank the government and commend the government for bringing this bill. It is timely, it is necessary. It will be supported by the civil service. We understand that we have to abide by this law. We look forward to doing it. We look forward to promoting standards in public life. I have shared this bill with senior civil servants, and I want to assure everyone that we are committed to, in the civil service, to abiding by the rules and regulations set out in this bill, and to promote standards in public life. Thank you, Mr. Speaker. Thank you.
I recognize the honorable member from Easton.
Thank you, Mr. Speaker. Mr. Speaker, I shall be very brief. Let me start by also congratulating the government. What I do know is that when I was a part of that government, the PPM, we always strive to ensure that honesty and integrity was a part of the administration. I am pleased that all those who have since joined has followed suit. I would expect no less from them. So I join the chorus of congratulating them in bringing this bill. I think it's necessary, always has believed it's necessary. I should say, though, that I had a number of concerns with it prior to the circulation of those amendments last night sometime. And I had seen some mistakes in it, like Section 30, but I noticed that Sabamba, what his name is again, Mr. Belay, has Bemika or something like that, the draft person has now spotted those and correcting them. Mr. Speaker, and many of those that the member from Northside, because he and I had lengthy discussions on this bill since it has been circulated, that he has highlighted were concerns of mine as well. So I'm sure at committee stage we will be able to address those. Mr. Speaker, here the Premier in his presentation of this bill, and now the Attorney General speaking about the perceived conflicts in a small society such as ours when it comes to, in particular, statutory bodies and finding people and the balance we have to try and maintain, i.e., the expertise that is needed and where that expertise comes from, or whether or not we can put people there without the requisite or what we think is a requisite experience or expertise, and what will become of those statutory bodies. And I think the Premier used an example of the planning authority. And I don't know if we have fully appreciated that planning authority, in that in many instances, people on the planning authority, and I can think of one who's a very good friend of mine, no disrespect to him, would be bidding or potentially bidding on projects even before they come to planning, because the developer or builder is looking to do costing of that development, especially construction, and would ask these people to submit bids or give them a preliminary, or get them to do a preliminary review of those plans. And then once it gets there, I don't think with any disrespect to any of them there, they would probably, if it could be perceived, yes, that that is a conflict because you had done this 3 months before or 6 months before, but what will happen if that person says, well, I don't even think I'm going to get the contract, and don't declare that in good faith? I have seen so many times that the planning tribunal has overruled on perceived conflicts the decision of planning. I can think of one development in my constituency where the developers lost the whole development because a member of planning had signed a petition and declared it but hadn't left the room. These are the things we need to be careful with, because it could very well create a problem for developers. And then, regardless of how many people we have on those, like planning, the majority of them are involved in the construction industry. And the majority of them may very well conflict or have a conceived conflict. Then we can't hear the board, can't hear the matter. And this could happen on a lot of those things. So I don't know how the Attorney General or my good friend, perceived good friend, the Premier, could explain that to us. perceived former friend, Mr. Speaker. Anyway, I would like to hear from the Premier in his response if those things had been considered, because they resonate with me because of other experiences I've had, especially in my constituency. And as a member of the planning board for many, many years, the Minister for Lands and I were members of the planning board for many years and had many conflicts on there, not between he and I, but, and those are the things that I have concerns about. Because the appeals tribunals for planning has this way of talking about natural justice. And usually that is the grounds under which they rule against planning. And we cannot have too many of those against planning, because development is our stock market in this country.
True.
Mr. Speaker, at committee stage, there are a few other ones that I believe I'll question to see if there is some discussion. But certainly, Mr. Speaker, we have to be extremely careful we don't lose too many people from our statutory authorities. The other one that I believe we need to think about is Cayman Airways. We remember when that was a political football, now it has become the sacred cow. Wherein I remember we come into Parliament and doing an indemnity for all the members. Will that be required any longer? Because that's the statutory authority, isn't it? Statutory board, company, whatever we want to, entity, whatever we want to call it. But I think someone needs to, I don't know if the Deputy Premier has thought about this, but will that indemnity be no longer be required now that we will have a standards in public life law? But certainly that is a matter that needs to be addressed. It needs to be looked at. I think there are a couple other statutory authorities that we have, that those indemnities made by Parliament, and I think Cabinet has made some too. I can't remember, but whether they were agreed by Cabinet and came here, but there are a number of those boards. I think the one West Bay as well, the Turtle Farm, I think is one. It has to be approved by the LA. I understand that, but my question, Mr. AG, since you weren't here, Mr. Speaker, through you, is: will they no longer be needed now that people have to declare their interests? But of course, those indemnities, I think, was to do with the expenditures of money, and they wouldn't be held responsible for any incurred debt, whether they're needed no longer, whether or not they're needed no longer, we really need to look at that too, because people just spend money without any concern because they're not going to be held responsible. So, Mr. Speaker, I support the bill, and I again commend the government for doing it, for bringing it at this stage. And I believe the amendments that were circulated will address the majority of my concerns. So, with those few words, Mr. Speaker, I thank you.
We'll pause for the luncheon break and return at 2 p.m.